Greetings, MSW students, and thanks for listening. This is Greg, and I'm going to provide you with a basic understanding of California laws and ethical practices that govern and shape social work practice. So just give me a minute here to get my view up the way I want it. Okay, fantastic. So many of you have practiced outside of California. Many of you have practiced in paraprofessional roles. Some of you have practiced in roles that don't involve direct practice. And so this, much of this information may not be new to you, but I'm still going to cover it in a very basic way so that you're prepared to engage in social work practice here in California. Also, because you're transitioning to be a professional. So key legal concepts and ethical concepts will be introduced to you. This will help you prepare for the engagement skills workshop that will happen, where we'll talk about how to discuss some of these situations proactively and informatively with client systems that you may be serving. And then the B course site, after you watch this, has a variety of other things that I'd like you to watch and read and then think about, and then there's a quiz at the end as well. For those of you that are strengthening organization and community macro students, some of the specifics around clients may not apply to you directly, but I would say that anyone working in a directorial role in a social work or social service agency typically gets consulted a lot about ethical and legal concerns and frequently has to convene a variety of experts to decide what the agency's response might be, both in terms of what represents standard practice in that context, as well as dealing with exceptional circumstances. So hopefully you'll find a way to make this relevant to you as well. So the first thing I want you to take a look at is what the scope of social work is in California. So every profession has a scope, which basically is the boundary that's drawn around what that profession can do or not do. So for example, nurses have a scope, and there's certain things that nurses normatively perform, and then there's things that are outside of scope for nurses. Same thing for doctors, same thing for psychologists, even building contractors and mechanics. Pretty much every profession has a scope, and social work does as well. That scope in California is defined by our Welfare Institutions Code. And so we're expected to have a special knowledge of social resources, community resources, of human capability or capacity, and also psychological or unconscious motivation in terms of how that may determine behavior. So we're expected to know that. We're expected to help people achieve social adjustment. We're expected to use counseling of a non-medical nature to provide information and referral, to coordinate or arrange for social services, to explain or interpret psychosocial conditions, as well as to help communities organize for improved social or health services. So it's a pretty broad scope, but you'll notice that we don't do things like provide medical treatments. Even if you have medical training, even if you are certified in some kind of alternative medicine, such as acupuncture, that is really outside the scope of what you can provide when you're in a social work role. Also, if you have a previous legal background, also you should refrain from going outside of the scope, even if you have knowledge, because it's just part of ethics is just staying within your scope. So hopefully this makes sense. The second principle that I want you to think about is the principle of informed consent. So essentially, if persons are seeking helping services of any kind, they should be fully informed about the purpose of those services and any risks related to services and their rights to refuse services or withdraw consent for services. Normally, this is done verbally, somewhat briefly, and many agencies, particularly mental health in nature, have a signed consent form that clients must sign. before they can engage in treatment services. When clients are dropping in crisis or coming for more kind of episodic care, this may not be as well attended to. It's just sort of done verbally usually. And also when you're treating clients in the context of a medical system, usually informed consent is done at the time of admission, and probably covers any number of professionals, including social work, that may be seeing a given patient during a given healthcare encounter. Social workers, we protect vulnerable clients, and it's particularly important that we consider what the cognitive or intellectual capacity of the client is, what their language ability or capacity may be, as well as their literacy level, and to take great pains to make sure that the information about services and related risks and requirements are delivered in a way that the person can actually understand. We also have to determine, in the case of clients who may not be adults or may not have the capacity to consent to services cognitively, that the consent for services may need to be discussed with the appropriate person. In the case of minors, that often involves interaction with a parent or a guardian. And for adults or older adults who may be incapacitated, that frequently involves discussing with their guardian as well, or conservator, or whoever their identified decision maker might be. Finally, social workers are advised to talk about any technology that may be a part of the services, and to make sure the client has access to that, and that there aren't unintended risks involved in that. So that may be working in a healthcare system and having an electronic medical record, and simply explaining how records are kept in your setting. The third principle that I want to discuss with you today is how to meet social work standards of care. And so this is a little bit tricky because you're at the beginning of your professional learning, but you are considered a professional, and or professional in training is probably more appropriate. And you are expected to deliver services that meet reasonable standards of care for social workers. Essentially, this is related to protecting the client's right. Clients who receive social work services have the right to receive competent services that are within the scope of our practice, as previously discussed, and are delivered in what's called a reasonable and prudent manner. And so standards that can be applied are the standards of reasonable care, which is usually how that's usually determined is thinking about how any number of reasonable social workers would act in a similar situation. And that sort of establishes what's known as a community standard of practice. And so when social workers practice within scope and provide reasonable care that meets general community standards of practice, they practice generally competently. When they fall outside of that standard of practice, then we are potentially guilty of negligence or malpractice, what's considered social work malpractice. And that means that either we're performing a professional act that fails to meet community standards and is harmful or does directly harm a client system, or we're failing to provide an act or a service that one could reasonably expect a social worker to provide a client in a similar situation. So just to break this down, so one example would be if you're working in a case management program and that's your scope of practice, and you are applying a client system, let's say a family, for some kind of housing program, and you are expected to complete and submit paperwork on behalf of the client, and you forget to, and then the housing list closes and it won't open again for another 5 years, that's definitely considered negligence. It would be reasonable for a client to expect that you would have taken care of that part of the duty that most social workers would take care of, and you did not, so that's an act of omission, and it led directly to a kind of social harm, i.e. not having access to housing. So there's many contexts in which social workers practice, and reasonable care is also kind of driven by that context. And so it's a really good discussion to have with your field instructor during your orientation period to get a sense of what are the standards of care delivered in that particular setting, and to figure out how you can, even in your first assignments, meet that standard of care, particularly with input from colleagues and your field instructor, training and orientation, and of course, drawing on your prior experiences and your current coursework as well. Probably the most obvious standard that we must uphold in California is confidentiality. And as most of you know, there are always exceptions to confidentiality. And taken from the 2017 Social Work Code of Ethics, that we have to take pretty cautious measures to protect the confidentiality of all of the information that we obtain in the course of providing a social work service. And so that means things like being very aware of who you're disclosing information to and whether or not that information is protected. That includes making sure that client records or private client material isn't left out in the open or isn't discoverable by other persons, and just exercising a lot of caution and prudence, both in your verbal and in your electronic interactions, to make sure that the client's privacy is well protected. Normally, and this is what our skills workshop will focus on, you discuss confidentiality with clients immediately, and you also describe any exceptions to confidentiality. So there are exceptions where the client has agreed to waive their right to confidentiality, or where there's compelling professional reasons or legal reasons, such as to prevent serious, foreseeable, and imminent harm, where you actually have to. You don't actually have the choice of upholding confidentiality. You actually are mandated or required to break confidentiality, and having a very upfront discussion with your client system about that is important. Also, social workers in some settings, in many settings, see families and see couples or see groups and multiple members. And so in that instance, it's incumbent upon us to clarify among those members what the rules of confidentiality are among the members, and to uphold whatever agreement we stated. So for example, if you're working with a couple and you see them sometimes together and sometimes separately, being really clear about the policy of whether or not the individual sessions are shared, that information is shared in the joint session, or whether it's never shared, or under what situations it's shared or not shared. Also true thinking about working with children and their parents, being really clear with both components of a family system, what the other may know about what's shared about the other. It's particularly important to think about a parent's right to know, what's happening in a counseling relationship with their child, but also as children age, their privacy and confidentiality becomes more important as well. So important things for you to think about as you enter a practice role in California. There are exceptions to confidentiality, and some of them are voluntary. So usually, in many cases, I was allowed to share information with other members of my agency or my treatment system. So when I worked at a hospital, anything that a patient told me, I could share with the doctor, the nurse, and place in the medical record that could be read by any treating provider in that system. So if you're working in a large system that's multidisciplinary, where records and care is collaborative and shared, it's important for the patient to understand, or the client to understand, that that's routine, and that when they agree to services and consent to services in that setting, that information is shared among team members. Also, when sharing outside of that team or a treatment system, which you frequently do as a social worker, particularly because you're often coordinating or collaborating with other providers, that typically you get a signed release of information Usually that's good for 1 year. That allows you to share information electronically, by phone, so on and so forth, for the purposes of coordinating care. Um, Clearly, whatever disclosure rules you talked about with your clients, particularly if you're seeing a family or a group, obviously they consent to those rules, and so you may make exceptions as long as they were described in advance. And then let me move to mandatory reports. There are situations in California and in most states actually where you're absolutely required to break confidentiality because they're seen as a compelling professional need. That relates to foreseeable harm, imminent harm that you could potentially prevent or where you could be a protective factor. So as you go through the module, you will have some videos and materials that I'll have you look at that will be a little more detailed. But on a high level, what I want you to be aware of is that you are a mandatory reporter if you have a reasonable suspicion, which again means that most people in your position would feel suspicious that child abuse or neglect was occurring. Then you are a mandatory reporter. Also, that you hold the same obligations with respect to elders. Elders in California are defined as persons 65 or older. And dependent adults would include anyone over the age of 18 who has a significant dependence on other people for their activities of daily living. So it might be a person with a developmental or intellectual disability or severe physical or mental health disability where they were unable to meet their basic needs without assistance. So those adults are considered dependent adults. They're also often very vulnerable to abuse and neglect, both from family members, community members, and residential treatment providers. And so being aware of them as a protected class is important. In California, you are also allowed to break confidentiality when you believe the client poses an imminent danger to themselves, and that's frequently related to suicidality. And in that situation, typically you would consult a supervisor on site immediately, in all these situations, in fact. And sometimes you would arrange for mobile crisis or police or medical transport to a 5150 diagnosis and assessment center. Usually that's a hospital where they might engage in a client being put on a 72-hour hold to maintain their safety and further assess what it would take to keep them safe. In California, there's also, and also in other states, there's also the Tarasoff ruling that affects practicing social workers, which means that if we have reason to believe that a person poses an imminent danger or grave threat to other people, and that other people are identifiable using reasonable means, we also have an obligation, usually to initiate a 5150 hold to contain the individual that we're concerned may be homicidal or pose a grave threat. So usually that involves invoking the 5150 and some kind of hospitalization. It also involves usually working with the police. It also involves making reasonable and immediate attempts to notify the person or persons that the dangerous person intends to harm. And so this is obviously very upsetting to think about. And what I will say to you is that the most important thing is just to be able to recognize that you might be in a situation like that and seek immediate supervision and consultation from your site. All right. And then finally, that whenever you're sharing information, whether it's voluntary or mandatory, to understand that you only typically share the minimum amount of information to accomplish the necessary goal. So, for example, you don't necessarily send all records or disclose every single past thing that may not be relevant to the reason why you're disclosing the information. So judgment about what's essential information and what's non-essential information, and sharing only the most essential components is a principle of related to confidentiality. So even when you're breaking confidentiality, you're still very thoughtful about what it is you're sharing and why. So let's talk a little bit about the things that have been confusing to past students. This isn't to scare you. You're learners. You're gonna make mistakes. You really are. Even experienced professionals make mistakes of these magnitude and nature, but it is to just illuminate the things that you need to be aware of. So we have had many students who go outside the boundaries or scope of social work practice. Often this is with clients that are younger than them, and they are in similar age categories, and they may engage in an overly informal relationship with a client. We've had students engaging in texting with their clients that was not of a professional nature and seemed more like a friendship type text. We've also had students give clients rides in their personal vehicle outside of hours, and do things like that that give concern and potentially go outside of the boundary or scope of what a social worker in a given context should be doing. Also, there have been times when our students held other knowledge, maybe legal knowledge or medical knowledge or even mechanical knowledge, and they performed a function for a client that the client needed, but that was clearly outside the scope of social work practice. So, again, not to scare you, but I did have a student who knew how to dress a wound because she had been an EMT. She was doing a home visit. The client had an abscess, and she dressed the wound, but she wasn't in an EMT role. She was in a social work role, and she went outside the scope of our practice, and that's just where she got confused. So just being aware very clearly about the professional boundaries. We have had students break confidentiality. There have been students, the most common thing is students post things on social media about their work, about a client or their agency, sometimes with photos and sometimes with text, where it just becomes clear what they're talking about. And I strongly discourage you from using social media to discuss anything that's client or agency related. It's really generally not appropriate, and so to be really careful about that. Also, there have been situations where a student has been in possession of private information, such as client records, either physical records in their backpack or bag, or records that they've downloaded on their devices and had phones as well as computers, and then had either lost their devices or backpacks or had them stolen. And then there's a potential breach that way. And then there have been times when students have broken confidentiality by telling one client something about another client, particularly in a school setting or a setting where a residential setting where clients may have social relationships with each other, and there have been unintentional disclosures of that nature. So to be super careful about that. Many students feel uncomfortable responding to risk and breaking confidentiality. That is something to review very carefully as you're being oriented to practice in your setting. When I was a student, I failed to identify a suicidal client that I had just seen. Fortunately, the client saw a psychiatrist right after me, and the psychiatrist caught the risk that I had not caught and initiated a 5150 hold. But of course, it was discussed and reviewed with me, which of course was embarrassing. But on the other hand, I knew what to do and not do in the future following that. So I will say it's something that I want you to be really open to instruction on. There have been other times when the student really did understand that there was a risk of some kind, but they just didn't want to break confidentiality. They didn't want to get the police or authorities involved. They had values, related to that, or just were concerned that their client would be treated in a biased or unfair manner. And so they knowingly refused to make a report. And some of those students, even when faculty and agency have directed them to make a report refuse to do so. And I just want to say that in field education, you're supervised by your faculty member, you're supervised by your agency field instructor, and whether you agree with their instructions or not, particularly related to managing risk, you really are asked to follow the person who has the license or has the authority and is legally responsible for your work. We'll definitely engage in a consultation process with you when you have concerns. Students often have great concerns, and often they're ethical dilemmas that the supervisor or faculty member aren't fully considering. But after bringing those to the attention of the people who supervise your work, we do require you to follow the instructions, or you will not be able to continue in field education. So just be aware that that's the consequence here. And then finally, when you detect risk, when you provide informed consent, when you discuss confidentiality, all of this needs to be documented in whatever record-keeping system or forms, physical or online, that your agency keeps. And you need to be able to figure out documentation standards in your agency and to have your documentation be high quality and appropriate to setting and done in a timely manner. We've had students that simply aren't turning in their documentation, sometimes for weeks at a time. And if you don't document ethical and legal practice, then it's as though you didn't actually do it. So it's critical. It's just critical for your field instructor, the agency, and for coordinating client care that you meet those standards as well. So what are some protective practices and resources? So the rest of this module, you can explore a little bit more about the different features of these items that I've been discussing with you. Your field instructor should be carefully reviewing your documentation and in many cases co-signing. When you have concerns, particularly immediate safety concerns, you always should be able to find someone within your agency that you can immediately consult. Often that's your field instructor, sometimes it's a program director or other providers, and often larger settings even have ethics committees or risk managers, i.e. Attorneys who are available to consult with you. Also, you can initiate consultation outside of your field of practice or your agency, and that may be contacting your assigned field faculty member, calling Child and Adult Protective Services hotlines and getting consultation that way, or finding other identifiable persons who have related expertise and experience who can give you their opinion on how you might proceed. Please complete this module in full. There's a number of videos I would like for you to watch. There's a number of materials I would like for you to review and refer back to. Please fully engage in your coursework, particularly Social Work 240. There is an ethics module, and there's quite a lot of related reading and a key assignment. And then if you decide that you want to be licensed in California, when you finish our program, you will be asked to take, while you're an associate social worker, a law and ethics course, online or live. And you're also required to take a law and ethics exam within 1 year of being registered as an associate. So I just want to say your education in this domain will continue throughout your career. It is confusing. A lot of it is sort of anxiety provoking, and also some of it's frankly boring. But just part of being any professional is that you understand the law and ethics that govern your professional actions and decisions, and you take responsibility for being up to date and making sure that your practice is in conformity with standards of community care. Thank you so much for attending to this brief overview. Wish you the best in reviewing the materials. And I also encourage you to bring your questions to field seminar. I'm also going to create an opportunity for you to post your questions on a discussion board, and one of us will reply to those as well. Thank you so much.